For the past decade, major technology litigation functioned as a predictable financial transaction. The pressure builds, a check is written, and the gate seals shut. The recent multi-district litigation over algorithmic design and school districts illustrates this legacy playbook. Meta stands alone in the June trial because Snap, TikTok, and Google reached settlements. The standard lifecycle follows a set path. Platforms face a massive lawsuit, fight through years of discovery, eventually negotiate a monetary payout, and continue a core operations. Companies treat these cases as manageable balance sheet line items, allowing the product's underlying code and architecture to remain untouched. Over a single 6-week window, a coordinated plaintiff strategy completely moved away from that legacy monetary playbook to target AI developers. The current strategy targets the product's existence and the liability of the leadership team, moving away from the historical focus on minor redesigns or cash settlements. This threat matrix outlines the new legal architecture, replacing corporate damages. It identifies 3 prongs. First, securing injunctions to shut down product lines. Second, piercing the corporate veil for personal liability. And third, building binding federal case law before companies react. The simultaneous activation of these 3 distinct vectors creates a structural crisis for AI platforms that a cash settlement cannot resolve. The case of Nelson versus OpenAI, filed in San Francisco County Superior Court, serves as the primary case study for this strategy. While traditional wrongful death suits seek a dollar figure for a loss, the Nelson complaint targets a specific vertical product line, ChatGPT Health. The plaintiffs are seeking injunctive relief, asking a state judge to issue an order that would entirely halt the product's operations. This maneuver bypasses the evidentiary process of proving a software design defect. It relies on a different legal mechanism that requires less technical discovery to initiate. Framing an AI harm as grounds for an injunction shifts the judicial objective from pricing the damage to halting commerce. The specific statutory mechanism being deployed is the state-level Business and Professions Code, which prohibits the unlicensed practice of medicine. The plaintiffs are using ChatGPT's own product architecture as the trigger for this statute, specifically the platform's long-term memory feature. This flowchart tracks the legal argument. By storing a user's substance use history across multiple sessions and recalling that data to provide personalized dosing advice, the software legally matches the definition of an unlicensed medical advisor. This clinician licensure strategy is being replicated across jurisdictions. The Pennsylvania Attorney General filed a parallel lawsuit using the same Medical Practice Act hook against Character.ai. A licensing violation is exceptionally dangerous for developers because a judge only needs to determine if the software's behavior matches the statutory definition of medical practice. The Nelson complaint introduces a second tactical demand that moves past corporate entities to target individuals. The lawsuit explicitly targets OpenAI chief executive Sam Altman, attempting to bypass the foundational legal protections of the corporate veil. The mechanism used against him is a count of negligent undertaking. The pleading alleges that Altman knowingly accelerated the public launch of GPT-4o while disregarding internal warnings about foreseeable risks to vulnerable users. Naming a chief executive personally changes the scope of the company's internal discovery process. Because of this specific charge, executive calendars and launch readiness memoranda are now legally exposed targets. When specific public launch decisions are litigated as acts of negligence, internal model safety records become discoverable evidence of personal liability. The final vector relies on a broader jurisdictional strategy, deploying parallel filings across different levels of the judiciary. This dual-column layout illustrates the division of labor between the courts. State venues handle one specific task, while the federal venues handle another. The state forum provides immediate tactical leverage. Plaintiffs utilize local consumer protection laws to pursue rapid injunctions or massive financial penalties. The Couture class action privacy case in California is a prime example. It frames chatbot data routing as a wiretap violation, leveraging a statutory damages framework of $5,000 per violation. State courts serve as the financial tool to force immediate pressure that the larger structural threat is building within the federal system. The primary objective of the federal forum is establishing binding procedural precedent rather than extracting immediate payouts. In the Northern District of California, United States District Judge Richard Seaborg delivered a pivotal ruling in the Solberg case. Judge Seaborg denied a motion to dismiss, refusing to defer federal authority to parallel state proceedings. Holding this federal forum open on a chatbot to homicide case creates a procedural template for future litigation. That template is already being ported to other jurisdictions, including the Joshi case in Florida. These early federal filings are quietly establishing the foundational case law that lower courts will cite for the next decade. When these three distinct vectors converge, they form a tightening perimeter around the developer. This coordination is not the result of a central plan, but a network effect. MDL lawyers, state legislatures, and federal judges are all moving toward the same target from different angles. A procedural victory for the plaintiff bar in any single venue instantly validates the architecture for the others. In this environment, defensive tactics like outspending opponents in discovery are less effective against direct injunctions and personal liability. The shift in litigation strategy means companies can no longer assume that legal friction will remain a manageable corporate tax. For product operations leads, the mandate is clear regarding vertical integrations. Deploying features that parse user health data or utilize persistent memory invites legal challenges that seek total product shutdowns. For artificial intelligence founders, corporate launch culture now carries personal consequences. Accelerating model releases while overriding internal safety warnings is increasingly being litigated as a matter of personal negligence rather than corporate risk. The new litigation architecture is designed to do more than extract a penalty. It is engineered to hold leadership accountable and halt their code entirely.